Hi, my name is Laura Morrison, and today's topic will be the L-1 non-immigrant visa. The L-1 visa is a visa that is carved out for multinational companies to allow for either managers or executives or employees that have advanced or specialized knowledge to transfer from that foreign entity into the U.S. company to assume those same roles. So in the L-1A category, we're dealing with executive and managers, and the L-1B is for specialized knowledge or advanced knowledge employees. The L-1A allows for a visa that is valid for, the maximum amount of time that you could stay on an L-1A is 7 years, and L-1B is 5 years. The other example, the difference between the two is that the L-1A can ultimately lead to a green card in the filing of an I-140 petition as the EB-1C, which is instead of a temporary transfer of a manager and executive, that goes from temporary to permanent, and that is saying that this person is going to stay on in the United States and then they can apply for their green card. So in that capacity, to qualify for the L, the individual must show that they have worked at least one out of the last 3 years for a qualifying company that has a relationship with the United States company. The United States company and the foreign entity must have at least 50% common ownership to qualify as organizations for L1 purposes. So you look at the qualifying relationship of these two entities, and then you look and make sure that they are active and doing business. So the application for an L1, when you submit an L1 petition on the I-129 form, it goes into 4 parts as I see it. And the first part is about the individual, which we'll get back to. The second is showing the qualifying relationship, which you would show the corporate documents and whether it's share certificates, just to show how these two companies are related. They may have a parent in common. The foreign company may own the U.S. company. So as long as we show that these entities have at least 50% common ownership, then that's the piece that will be showing that the company qualifies. And then there's the documents for the American company, and there's documents for the foreign company. And we typically show a lease agreement for the office space, a couple of bank statements, the payroll records or tax returns. We show that both sides of this equation, the American company and the foreign company, are actively engaged in business. Then the individual piece for the person that is going to qualify for the L1, they need to show on the L1A side that they have managerial or executive experience. And that can be either that they manage other professionals or that they manage a department or a branch of the entity, and they basically run it on their own island, only reporting to senior management. So a hierarchical chart is typically submitted to show where they stood on the foreign company's chart and then where they will be in the U.S. company's chart. And if it's based on being a manager of other people, then you need to show those subordinates, direct reports, and how those direct reports are also professional positions. And if there's indirect too, certainly that makes it the case stronger. But the first line of underneath that person is really critical to showing the qualification of a people manager. And then to show that they manage like a department or a division of the company, they don't necessarily have to have people that subordinates that answer to them. But they do have to kind of operate on their own island, meaning that they are in charge of that department. And they probably only answer to the executives, the board, the owner of the company. So they have a lot of discretion and leeway and decision-making in day-to-day activities of that department. So the documents that we are able to show in an L1A people manager is the credentials of those people that are subordinate. And then for the L1A that is a manager of a department, they would show how that piece of that company, that department, is critical to its operations and how they're only getting very limited oversight by the company's executives or people that are on the hierarchical chart above them, and that they they have wide discretion and leeway in making decisions based on their positions. And that's in their hierarchical chart. You might see that person has a separate branch right under the executives or top managers, and that would qualify the person if they're able to show that that person does operate pretty independently in that function. Now, the nice thing about the L-1B is that it still allows a foreign national to come in without having that executive or managerial experience or a 4-year degree or a master's degree in business or anything like that. It is based on their knowledge. It's based on the knowledge that is critical for them to come from the foreign company to show that the U.S. companies needs to do certain things. So sometimes it is proprietary software that they have specialized advanced knowledge. There's a difference between the two. The specialized knowledge is that sometimes it's just limited to the company. Like I said, proprietary information. So the foreign company there's a startup for the US company, and they need to be trained by someone that knows all of their software programs and operations and how they do business, that they've been entrenched in it and they have developed over years of experience that specialized knowledge that is useful to the U.S. company for them to get up and running or up to speed in having that knowledge come across from overseas and really assist the U.S. company in whatever it may be. So the specialized knowledge is different than advanced knowledge in that the advanced knowledge is people that have more experience than most in a similar position. So that advanced knowledge may be, for example, in AI. That AI is a new technology, and you may have specialized knowledge as how a company may use it, but having that advanced knowledge and the technicalities and the know-how of how it operates would be something that may qualify for advanced knowledge if that relates to the company's need. And the L1 is, like I said, it's a non-immigrant visa, but it doesn't matter if you apply at a U.S. consulate, as there's no strict non-immigrant intent on this, which means that you can say that you are going to apply for a green card. It would not affect the non-immigrant status of the L1. And these are I-129s, and they can be processed with premium processing. I have to say that they are cases where we commonly see RFEs, especially on the L1Bs. And the L1As, if there is a strong evidence that is submitted, you may not get an RFE, but certainly in the specialized and advanced knowledge, it becomes challenging because you're basically having to take the company's word that this is advanced knowledge or this is specialized knowledge, and that it is required from the foreign company into the U.S. company, and that person has that ability. And it would be that if we had to train an American, it would take a long time to get up and running to the speed that this person has. And it is temporary in nature. So hopefully after those 5 years, the maximum that you could get on an L1B, that knowledge has successfully been imparted to the U.S. company employees in that same position, so that there's no need for them to have a green card. So that's why the L1 can parlay into an I-140 petition, which is a permanent petition for an alien worker, and then the green card comes after that. So the petition is the underlying reason for someone to ask for a green card, and the green card itself is a permanent residence, right? So it's an I-485 application to adjust status from within the United States, or if you prefer to apply for whatever reason in your home country, you would come in on an immigrant visa. The preparation of the L visa, I always have in mind that there could be an RFE. I'm kind of forward thinking in where there might be more documentation that we can get as needed. And sometimes that's showing how the software works. If it's a software program for a specialized or advanced knowledge, that you have to educate the officer on what makes it specialized, what makes it advanced. So they're very good visa options for multinational companies to see if they can qualify for the visa or the L1 status, the company, based on at least 50% common ownership of the companies. And there can be many companies that may have that same relationship. And if that's the case and there's other qualifying, they may be able to get an L1 blanket, which means that the L1 company, once you submit a company application and they show that it qualifies for a blanket L, then they can just send the individual's information moving forward for the next 3 years. So if it is a huge multinational company where people are coming and going all the time, that may be something to be considered, which is the L1 blanket. And there's a couple of ways to get there. So having $25 million gross for the company is one of the ways. And you need to have at least 3 companies that are all related to be able to apply for the blanket. So that's something to consider if this is a bigger company. And it's challenging with smaller companies because if it's a 10-person company, you may have difficulty showing the hierarchical chart and where they fit in and whether or not that qualifies as a manager. Or the executive positions certainly are a lot easier than the managers because they're either executives and the managers can either be manager of a function or management of other people. So the evidence has to be able to show that the petition is approvable. And it's by the preponderance of evidence standard of burden of proof, which means that if it is more likely than not to be true, then you have satisfied that burden. So the key takeaway from the L-1 is that it is for multinational companies. The person must be working at least 1 out of the past 3 years to qualify for the foreign company. Any time that's spent in the United States during that time period counts against them. So it's really critical to look at the travel history, especially if someone's coming. A lot of times, if it's a startup for a U.S. office as an executive, they're coming in and out. If that time is spent in furtherance of that on a B1 visa, then that time can be taken away. So there's these little nuances that certainly come into play, and a qualified immigration attorney can help you get through it to see if this is a viable option. Have a good day.